Start with audio. List. View. So far, just one button. Ooh, that's really loud. Hope there's nothing. There you go. Admit. Boom. All right, so this is evidence. Let's see. Did we finish off that last chapter? I don't remember. We were in, what was it? It was the one on chapter 12. Evidence. Where are you at? Right there. Boom. I think we made it through this one. I don't remember though. So it did not tell me where we left off. So I'm going to scroll through it real quick because I think we're on to reviewing for an exam today. Miranda, incriminating statements, made it through that. Voluntariness, totality of the circumstances, Miranda, invocation. "14 days the break, when they're not required, public safety exceptions. Excuse me, we're ready to bring up, slow down. Yeah. Okay, so we talked about silence. Basically, you can't use that against somebody, but you can use impeachment there. Here's where it talks a little bit. We'll talk about this one for a minute. I think this might be where we left off because I remember talking about silence. I remember we talked about it in other places. So probably pretty good for me to break there. That way you can see the slideshows. We talk about stuff, but I don't necessarily have to have it up. And you guys can follow it on. You guys all have to right, or I'll have access to that. And so we can move on from there. All right, so this is whenever it's talking about silence. Remember we said that, if you had your rights, you've invoked your rights, those types of things. The biggest element to keep in mind in terms of whether it's you're the one being questioned, you're the one who's the officer doing the questioning. Invocation of rights. If it's not clear and unequivocal, it didn't happen, right? I think I want maybe anything that's kind of quasi in nature, not a. I mean, that these people. Apparently, those two. Second, let me catch on. Yeah. Yep. All right. And so last time we were talking about when you invoke your rights, you need to be clear and unequivocal. It needs to be direct. And if you look at it from either whether you're the one being questioned or the one doing the questioning, on that side, the invocation of rights, Fifth Amendment, you refuse to incriminate, you refuse to answer that question on the ground that may incriminate you. But really what it is it's the invocation of your Sixth Amendment right to counsel that's of more consequence. It changes what's happening, right? At that point in time, your questioning stops and basically you move into you must meet with the lawyer. And then from there on out, any interrogations usually set through the lawyer themselves unless the defendant themselves approaches the police or whoever would be the one asking questions, usually the police. In that case, whenever you make that approach, realize that itself is a waiver. And it's not just a waiver for your right to counsel, it's a waiver against self-incrimination too. And so we get a waiver, one is a waiver of both. And that's kind of how that works. Here when it talks about silence, defendant's silence in the face of questions asked before or after Miranda warnings cannot be used for any purpose. Right? And then basically it's in that fact about pre-custody, pre-Miranda questioning can be used for impeachment purposes if they let her testify at trial. That's kind of the nature of that. Okay, here's what it talks about. Your right to an attorney is guaranteed by the Sixth Amendment. Realize that the history of this is kind of long, painful one. When we talked about the case we talked about last time, where it was the Brown versus, I don't remember. That was a death sentence case that was decided in a day kind of thing. And that was one, lawyer was actually appointed there. So it started out, do you have a lawyer at trial? Do you have it within processes that you need. And eventually that's what we talk about when we talk about Miranda. Miranda Escobedo moved it to the station house. Miranda moved it to the streets. And so here's when we're talking about what rights apply. That's that Sixth Amendment here. Or Sixth Amendment. So here's where that criminal trial commences for the purpose of the Sixth Amendment. When you appear. However, as we said with Miranda, remember, Miranda itself is at all critical stages. That's the phrase you want to remember there. And so that's why it goes all the way up to the streets. Evidence obtained by threats. I think we talked about that one a little bit, right? Common practice for investigators request a written response to the complaint being submitted. Yeah, because it can implicate. Court has held that investigators cannot threaten a person being investigated, loss of job, license, if they refuse to answer questions. We did talk a little bit about that last time. We started talking about the role of the those outside of the criminal justice system in this process. Remember, you or I, as regular citizens, we're not bound by the same restrictions that the governmental agents are. But when you start getting into some places like this, where you're dealing with whether it's private investigators, things of that nature, you can't do that. All right. Supreme Court established Miranda safeguards can play whenever a person's in custody. The functional equivalent. That's that phrase when it says functional equivalent. What that means is it doesn't have to be directly a custodial interrogation. It just has to be the equivalent, right? The same situation, the same kind of pressures involved, right? That's why we talked about when you grab someone, where you grab someone, how many officers are involved, are you taken anywhere, all of those types of things, because they can give you that same arrest, that same deprivation of freedom. It goes along with questioning, then you're into that interrogation. All right. So that's Messiah right there. It talks about once that adversary procedure begins, legal representation during interrogation. Right? So that's that. It says here, rights under Fifth and Sixth Amendment counsels are not identical, but are similar. If you notice, we mentioned when we were first early in the semester talking about constitutional rights, it's like you have elements of some that are repeated across different amendments. The Fifth and Sixth right here, but I talk about counsel is one of those examples. Okay. So where it talks about that adversarial process have commenced, right? When you're building up that history, so it started out that adversarial process. When you start moving that adversarial process, where it really attaches is once accusations have taken place, so charges, that kind of thing. All right. So there, when you get to the critical stages part, that's where it's everything that's adversarial in nature, and that itself includes police. Without the attorney's presence, obtain a waiver of the right to counsel after attorney's been present. Okay, so I'm trying to remember what this point right here was about. Which please. Yeah, you can't do that. So what it's talking about here is where they approached and got a waiver. It's like you can't even really approach for a waiver, and you shouldn't be doing that. They've affected their rights. So if you invoke your rights, if you make that approach, even to obtain a waiver, it's like, they already had counsel. You should not be in contact with them. They've got a lawyer. All right. And so that's what this one's talking about. 10-year-old kidnapping. Okay, so I can't remember if this is the one or it might be one of the next ones it mentions. Yeah, I don't think that's the same one. So there's a couple cases. I talked about them already. Right here. Prohibits the police from questioning. This is related to this is one of those where they're transporting the defendant, and they'd ask questions to get him to turn over the body. Right, that's this one right here, Brewer. I rolled back one too many. Right, officers question the defendant in their car, persuade him to reveal body. It's an error. Order trial. Right. is that offense specific? So we need to talk about that in terms of invocation and time. That one sucks. I need to get rid of it. All right, timeline. Have I done this in here before when we talk about timeline? Doesn't seem familiar. I think so. A little bit. Okay, good. So remember, you have everything that's involved in, up to the point of arrest. Maybe you got charged. Everything that comes afterwards, whether it's bail hearings or whatever. Okay. Wherever in this process you invoke your rights, they carry from there, right? So if you're already in the stage where you may be sitting in jail, kind of thing. When you invoke it, yeah, it's invoked related to your time in jail, right? So they can't approach you while you're in jail. But if it's related to a specific crime, and let's say you've been in jail and you've been released, you have that 14-day window, right? There's one aspect of it. Let's say if it's related to something that outside of the purview of those charges. Okay. Offense. Right. Once you've been charged with a specific crime, you request that attorney, it's tied into that process. That's why if you get it out earlier, it applies to more things, right? So this one, I think I'll give you a case where it's tied into bail. No, I didn't give you that one. Well, basically, what it was bail hearing, I think is where they were at. Requesting a lawyer specifically for that bail hearing. That's different. You're well into that process. That would only apply to that. That's not going to apply to anything else that you may not have been even arrested for. Right? And so the earlier you invoke that, the more protection it allows. And if you're far enough into that process, realize that there might be multiple times you'd have to invoke that same right because they may only be bound to whatever specific charges are being levied at that time. Okay. These may not take intended. Yeah, that's fine. Yeah, you have to get that voluntariness. Okay. An arrest for unrelated offense. Defendant here in this case confessed to a home burglary, but denied knowledge of disappearance of a woman and child from the home. Later confessed killings to his father. Question the defendant without the presence of the attorney, but after obtaining a waiver of Miranda rights, obtained confession. Since that Sixth Amendment right to counsel is offense specific related to the home burglary, they were able to use that confession. He's in here for one thing. This is something completely outside of that. Has nothing to do with it. And so someone else went and asked him about it. Okay. Once that right to counsel has attached, statements by the defendant must be excluded if police deliberately elicit incriminating information from the defendant. Right there. That's got a couple of elements into it. Right? You have that elicitation, I guess you'd say. You caused it to come forward, but it has to be deliberate. So that's that line in that car, right? I'm going to talk with the person. They're going to give me this information, right? Am I going to create a situation or is it going to be something indoor? Like I didn't. That just did occurred, and that person gave that information over. That's not me doing it. I'm not responsible for a rights violation in that instance. Okay? I remember this one. Supreme Court held that because the defendant had not requested an attorney to represent him, it's not necessary to assume that any waiver of the right to counsel had been given by the defendant in subsequent. They might not ask them in terms of subsequent interrogations. So in this one, what happened here? Do we have to formally Mirandize you each and every time that we talk to you? Ideally, we do. Right? But if you waived your rights once, they don't necessarily reinstitute them until you invoke them like they were to begin with. So that's what this is about, this case, right? The person did not invoke their rights. It's not necessary to assume that a waiver of right to counsel given by the defendant in subsequent interrogations was involuntary. And you can't make that jump. Brutton. So this is one related to multiple people involved in the crime, right? So if I have a confession from one person, it's got a couple parties to the crime. Should I get to hear for the confession from the person who made incriminating statements against the defendant here? Here's what you do. Make concessions to one of the defendants to get him to become a state witness, incriminate himself, one of the other defendants. Drop the charges against the defendant. Proceed trial against a single defendant. Right? We talked a little bit about this whenever we talked about that Rittenhouse thing. That's a really good example of that. You had a person there. It's a little bit different because it's not necessarily the same crime the person was being accused of. The person on trial is a little bit of a different crime. Weapons carrying is what it was. Murder, I guess it would be kind of a different, same crime but different parties. I don't know. In it, they mentioned this person's testimony. You could clarify this. They're not allowed to give it because if they do, they'd have to become either guilty or a state's witness, and prosecution was not offering witness. So you'll go along with this or we'll hold you accountable. Right? That's an interesting thing. And you can see where people's motivations can move things in directions that may not necessarily need to move. Yeah. Especially situations where there is sufficient evidence to go to trial against the other defendants. Prosecutors may do separate trials, using confessions against the trial, redact first defendant's statements to eliminate reference to other persons in that joint trial. So that's how you separate it, or you do any of those other options. So Brutton co-defendants were tried together and convicted. One of them had given a confession implicating statements, and they were used with just a limiting instruction to the jury. The limitation instruction was not adequate. So that one didn't hold up. Okay, so this is the one that establishes that impeachment aspect of wrongful confessions. So, let's say wrongful. You have a confession obtained in violation of the Sixth Amendment. That person takes the stand and they say something. You can reintroduce that invalid confession to show somewhere some false statements were made, right? Expression of those statements in the prosecution case was necessary, but it's no longer necessary here because you're defending you're impeaching the defendant, and so you can allow it in. Problem is well, we'll come to this in just a second. Problem with that is when you start dealing with things that are involuntary, unwarned, unknowing kind of thing, and yeah, it's involuntary. You got someone say something wrong under force. Should that lead to a conviction? Okay, questioning people in jail. So when you start dealing with informants, basically what you run into here is the same kind of situation you run into with officers. You know, the same kind of thing. They automatically become agents of the government if you start working with them. Essentially, as soon as you start working with them, they're practically an agent of the government, right? And so if you're setting in, it'd be the equivalent of, instead of a jail cell, just think back in the interrogation room with just one officer kind of thing. It's like that's not any different. Big line there is where the conversation go and how probing that person is, because they're just there acting as ears and not really trying to elicit it. It's not the same thing, right? Okay. 6 minute prohibits police from using jailhouse informants to obtain incriminating statements from a tenant charged with crime waiting for trial. Fifth Amendment does not have such prohibition. So that relates to that. Did you request a lawyer or did you invoke your right to be silent? Right? You invoke that right to be silent, that question will come back up. And then the last couple of these are way off topic. All right. Polygraph. We'll come back to that. We'll do voice spectrography. Right. Voice spectrography, inadmissible. Right. Makes it difficult to use voice prints without improvements in technology. So if you look at voice right now, I should just a bunch of lines that identify. Okay, this is the timbre. This is the different aspects of that sound. Whatever. Not as rigorous as what it would need to be able to be used in courts, right? So if that one's not as rigorous as what needs to be in courts, polygraph, right? Everyone's familiar with what polygraph is. They put the thing around you, skin, detect your heart rate, all that jazz. What exactly does polygraph test for? Do you guys know? You specifically know. Is it lying? Yeah, so it's in theory it's about lies, but it isn't that at all. What it actually does is they call it the galvanic skin response test. And so essentially what they do is the thing around your chest is for your breathing. That way you can check see how frequently you're breathing. They'll test your heart rate and sweating. That's that galvanized. So they're testing to see if you sweat. And so basically, if you have someone with high anxiety, sweats a lot, those types of things, you get very hard to read outputs. And so you have that interpretive element of it. So it's like, does it really do that? Well, you can see a biological response, then you have to interpret whether or not they're saying something that causes an emotional response. It's often it's just false. It's just no way to really tell that. But what I can tell is you're sweating and you're breathing heavier. And so that might just be stress, right? And so those things don't work, right? You produce false accusations in innocent people. There is no direct correlation there. And again, you're dealing with autonomic responses that ideally you're responding to or controlling on a subconscious level, maybe. What about your psychopaths? Think about those people. Like, they don't have a response to much anything. Okay, they're obviously innocent. No. Right. All right. I think that about does that for this one. So most states forbid the use of lie detector evidence in civil and criminal trials. Here's where it mentions stipulation. That's the only time that those things will come in. Both parties agree to, right? And so that's never a situation where that's going to have any real effect, right? Because if it had a real effect, one side would be like, "Oh no, we're not putting it." All right. Boom. Exact formulation from random warnings. Oh, that's way out of place. I don't know why that's in that place. Where it's got that section where it talks about the exact formulation of Miranda. That's the wording itself. That's just everyone hears the same wording. That wording is actually so consistent that most people just know, yeah, the right to remain sensitive. But it doesn't matter the actual wording. You just have to be informed that those are your rights. You have the right to remain silent. Anything, those types, and then you have a right to counsel. The format for this one, if I remember correctly, was either the officer on the scene said something. How was it? A lawyer would be provided or counsel would be provided if one was needed, not upon request, something like that. So it's just to notify you that you had a lawyer. That specific language sheet didn't have a substantive bearing on the fact that the person was informed of their rights. And so that's how I don't want to say nuance. Nuance isn't the right word. Petty isn't quite the right word either. But that's how refined, I guess you'd say, some of these cases get how micro level That's a really, you were informed of your rights. Is that form of that word, those words, is that really going to cause a major disturbance in how that event changed or how that event took place? No. All right. And with that, I think that does that chapter. So we need to move into a review. We've got, what is it, about 15, 20 minutes, something like that. Cool. All right. So we should be able to get to it. I might move you guys over here so I can see you better. And then I'm going to move this over here. Wrong way. Hello. Now I can see everybody. That's pretty. All right. So, exam 3. What we'll do is I'll make that ready, available probably. I don't remember if there's anything I need to do this week. I don't think there's anything I need to edit to this test itself. So maybe by Monday at the latest. I'll make this available for you guys, and I'll give you at least a week to complete it. I also need to double check to see if where I'm at in terms of quizzes and assignments. If I'm behind on one of those, I'll pop out one of those and give you a week to do that, and then I'll delay this a little bit. So that way the timing doesn't clump up on anybody, because I hate whenever that happens for people. I hate when it happens to me. That's horrible. Take the standard format of, was it 45 questions, multiple choice, 1 essay, 90 minutes to take it. Let's see, course chapters, was it 7 through 12 or something like that? I'd have to go back and look. That'll be outlined on Blackboard and in your syllabus, same way. Those will point out the same. From there, of course, no 4th, 5th, and 6th constitutional amendment rights are the ones that were of the greatest consequence in these sections. Be able to identify what those amendments cover, of course. If I said here's a good one. The fruit of the poisonous tree or derivative evidence. What are the ways in which you can purge? That poison is also known as what? Sometimes I call it taint. Like the evidence is tainted, because it is. Let's see. The exclusionary rule. What is it? What does it do? Why do we have it? Right? What is its purpose? Remember that its purpose dictates its use, and it dictates its exceptions. Right? So if we have the exclusionary rule, so we have reasons we exclude stuff, and then we have exceptions to the reasons we exclude stuff. Right? Those exceptions, be familiar with what they are. You're dealing with what is it? Good faith, independent source, inevitable discovery, exigency, those things. Let's see. When is I don't want to work it that way. When you say a functional equivalent to an arrest, like, be familiar with that phrase and what it actually equates to. The fact that it doesn't have to be I should say functional equivalent of interrogation. It doesn't have to be an interrogation itself that may require Miranda. It has to be the functional equivalent thereof. So if it's in that territory. When we start talking about what makes something an interrogation, right? When have we moved into that? The phase of interrogation is you have questions plus custody. So questions, where you get to invoke your 5th Amendment rights, right? That privilege against self-incrimination. Realize that that's basically anything that's likely to elicit incriminating statements from you. It's not just questions themselves. It's anything that can be. All right. Evidence, you know what that is. Mapp versus Ohio, always be familiar with that. That'd be like saying Terry versus Ohio or Miranda versus Arizona, right? Be familiar with all of those. You should know those always. So when we're talking about the exclusionary rule, we talked a little bit about its process, its history. So if you look at it, of course, it exists in the and kind of like that, but those things shouldn't be used against you. But it wasn't until what was it? I'm trying to remember the exact names here. You have the era where basically there was no exclusionary rule. It moves into the federal officers for federal cases, and then it moved into the silver platter doctrine, where local officers could violate those same rights as long as it wasn't federal officers. And then with Mapp versus Ohio is where it actually took effect, and or not, yeah. And so that's where they identify. It's like, yeah, state police have to follow these same guidelines, even in state cases. So you had first applied federal level federal officers, then it was federal officers, state officers within federal cases, then it's state officers within state cases, state proceedings. Okay. Okay. Yes, be very familiar with your exceptions here. You'll be given times where you'll be given a situation and say, okay, which of these exceptions would this fall under? Or so another example being, yeah. Okay. When we're talking about knock and talk, knock and talk. So just walking up somebody's knocking and talking with them. What exactly is that? Is that something that is governed in any way whatsoever, or is that something where an officer acts just like a citizen or a normal civilian? Basically, that line there is whenever it turns from something consensual to something not, right? Uh, directly, indirectly. That one. No, the specific ways in which taint attenuates. I think I've mentioned that before when you start talking about time, breaking custody, things of that nature. Mm-hmm. This really shouldn't be that bad. Okay, abandonment. What happens when you abandon something, right? So be familiar with what it takes to have something classified as abandoned, and then realize that whenever that happens, any privacy rights associated with it gone by the wayside. And also, if you were talking about the element of seizures too, like uh, um, there's no privacy there, that kind of thing. It's not anyone's, so it's there's no element of privacy there at all. Um, let's see. Hmm. Okay, plain view, those types of things. Remember, if we're dealing with plain view, you need to be somewhere where an officer is legally allowed to be. Plain view is not touch, right? Realize that plain view, open fields, border search is technically really, but those are places where there is no reasonable expectation to privacy. So technically, it's like really those aren't searches at all. Like border searches, you still have no reasonable expectation of privacy there. Okay. What is good faith? Totality of the circumstances. Be familiar with that phrase. Basically, that means that everything is a factor. Where we talk about plain view, open view, consent. When it comes to consent, know who can consent to what. Um, the concept of apparent authority might come up, and that's where it's like, someone has access to an apartment kind of thing. They have keys to it. They act like they own the place. It would be entirely okay for an officer to assume that that person actually has authority to be in. Everything there points towards that. Um, let's see here. When you start dealing with shared areas, how that works. Hmm. Okay. When it starts moving into like administrative searches or other searches, we start talking about like health, wellness, I should say welfare, not wellness, health, fire department, things of that nature. Realize that the thresholds there for allowing people entry into someone's house change drastically. Like I said before, the nature of the purpose there dictates it. If you're there for someone's benefit, you'll be given more latitude. If you're there to punish or to correct or anything like that, where it sits in law enforcement, that'll be more restricted in your actions. And so you have that interesting dichotomy. It's, am I really here for your benefit? And so that's kind of how that plays out in the functional world sometimes. Let's see. Oh, roadblocks, individualized suspicion, right? So roadblocks are allowable because they only offer a very, very minor delay. The intrusion there is so insignificant. What it gives the officers the opportunity to do is to develop individualized suspicion. So it's like, okay, everybody going through here seems to be all right. That one right there, though, right? That one. It's like, that guy's intoxicated, get him over here. Right. And so that's how they do that. It's like something over here is like there might be a couple of things that have queued up some suspicions there. Let's move this person over and dispel those real quick, right? Let's see. Search special needs searches. Be familiar with those. This is long. Got a lot of chapters in here, so a lot of potential questions. Fourth, fifth, and sixth functions. And you know that stuff. When it comes to businesses, when can they drug test you? Anytime they really want. You're an employee there. Let's see here. I saw that in there. I lost my place there. Ooh, closely regulated industries. Know what those are and its relationship to Fourth Amendment stuff. So if it's closely regulated, you're getting closer to that individual, and then those privacy areas start to attach again. Know the role of consent. When and where. What consent requires that same type of waiver as your Miranda does, right? Voluntary and intelligent. You know what you're doing, and you're doing it on your own. From there. Skip that. That reasonableness standards pervades all these things. Keep that in mind. It's like custodial interrogation, standard which you determine whether or not you are in custody. There still is that reasonableness standard. Let's see what else here. That's interesting. Okay, I think that one's talking about. Yeah, I might have some in here give you a scenario and you identify whether or not this series of questioning is acceptable or not. What factors were determining whether or not those statements were voluntary, things like that. So those are pretty easy to identify too. Let's see here. How many requirements are there in Miranda? You familiar with that? The different areas that it touches. Neal versus Biggers. That relates to due process and eyewitness identification. While we're talking about identification stuff, that aspect of identification, you don't want it to identify your suspects. It needs to be fair. The big thing there. Let's see. Lineups. Let's see, what was it? Lineups, show ups, the photographs, other ways you can make identification procedures. And should something happen and your previous identification procedures no longer be able to be used in court, remember you always had that courtroom identification process. It comes to constitutional rights. Your right to counsel has been upheld after you've been charged. So you can only have, you're only required to have those rights, that right to counsel, should you have been charged for it. But you always have that due process right. It doesn't need bias. It needs to be a fair lineup. Okay. If you're having a lineup, how many people should you have at the lineup as suggested by the Council of Judges? Ooh, I didn't talk about composites, pictures, sketches. You can do those too. Ways to identify people. Ooh, inventory searches. Why do we do those? Remember that those are tied into processing people and their things. They serve a few different purposes. Probably the biggest thing there is to make sure your department has a policy on it, to be honest with you. Because if you have policy on it, then you follow those policies, those procedures there. If you don't have policy on it, why are you doing it? If you don't have policy on it, you can't use any of that stuff because you have no reason to be in the vehicle in the first place. Stop and frisk. There's some stuff in here about that. You know what stop and frisk is, you know, its purposes, its thresholds. The thing in here that I see that's would be something a little bit uncommon, and they have some questions here about from 2004, 2012, with stop and frisk in New York. So if you go look that one up, you'll see it's like something like 80% of the 4.4 million stops and frisks, blacks and Hispanics. That's then they're doing it wrong. Let's see here. The rest of that stuff just aligns with standard definitional things. Oh, if we're talking about no knock or breaching doors, the reason why the reasons for having a no knock warrant, right? That danger there, destruction of evidence, suspect escape, so on and so forth. Ooh, what is a search incident to an arrest? Basically, what that means is that you've arrested someone, and whenever you develop probable cause for an arrest, you can search. You get to search that person the week span or whatever. Like if the vehicle that they're in is attached to that, something like you pulled them over, you can search the vehicle too. I just saw one here and I lost train of thought. Admissible recordings. When we start dealing with recordings, single versus party consents, the different aspects that we talked about related to that. But when it starts coming to difference between testimony, difference between evidence, and then I just saw it here. There's just another word that's on the tip of my tongue. No, I'm not seeing it now. Oh, I know what I love. Technology. That's what I was looking for. Technology's role, right? So that's one where audio could potentially fit in either role there, where you're dealing with it as used as testimonial or as just straight evidence. How we deal with it changes, of course, depending on its use or its nature. And then we start dealing with technology and its effects, realize that once you start using it to cross those spaces that are protected, that's where it starts to become no longer useful. That was KYLO, K-Y-L-O, where to use the temperature gauge on the house. We're trying to determine factors about aspects of it that could no otherwise identify unless they were actually there. And so that's where you've started to have that privacy breached. Ooh, elements of a warrant, right? You need a neutral and attached judge. You need a signed affidavit. You need a person or place to be searched, things to be seized, a person to be seized. You need probable cause, of course. When you're dealing with that, remember neutral and attached judge. If you don't have your lists of items to be seized or places to be searched or things of that nature, your warrant is going to be invalid. Let's see, is there anything else I need to say? No. Of course, you have the different warrant types. When we talk about different search warrant types, it's like, okay, search warrant, no knock, anticipatory, sneak and peek, all those different types. Know what they are, be familiar with some positive and some of the negatives associated with that. Oh, right there. Proceeds. What's that one? I'll talk about that one. Following that, we're getting real close to the end here. Drug dogs, right? Realize that what they do is all they do is create probable cause. They are not a violation of one's right to search because they don't detect anything other than something that someone has no possessory interest in, meaning no ability to even possess. When you're getting seizures and things of that nature, also realize it's that possessory interest. It's of concern, right? You have your privacy and possessory interests. Those are the two things that are related to items. Here, sneak and peek entry, consent. Ooh, computer searches. Remember the limitations there, the reasonableness associated with it, also the dangers. Patriot Act stuff. Yeah. Ooh, there's one case in here some mentioned that I don't know if I talked about directly. I mentions Alabama versus White. That's the one that dealt with anonymous tips. And so that's the one that identified. It's like, yeah, if you can corroborate the information there, then that's good to go. So otherwise, probably you couldn't use anonymous tips. Oh, and now for the essay. So 1, 2, 3, 4 potential essays, maybe 5. Page counts. Breaks. 1, 2, 3, 4, 5. I think 5. I don't know. We'll get to see what it says. All right. So the first one, know what standing is, right? Define what standing is. Define when does the defendant have it to challenge a search or of a place or things, and provide examples. So standing. When there have been violations of rights, when would you have that ability to use that to identify that, you know, that there have been problems and that evidence needs to be excluded? Okay. Next one, the 14-day rule. Define and discuss. What is that rule? What does it pertain to? What does it do? Why do we have it? Next one. Define and discuss 3 exceptions to the exclusionary rule and or fruit of the poisonous tree doctrine. Be sure to provide examples. Right? So you explain what that is, what taint is, how it's purged, and then some of those exceptions. And then the last one, so it's only 2, 3, 4. There's 4. It's just broken up weird. 5. In general, under the 4th Amendment, when is the required procedure? What is the required procedure when police arrive at a residence to serve a warrant? When are these requirements excused, and be sure to provide examples. So you start talking about things like that, not going to that nature. And then the last one. Discuss the application of the totality of circumstances test when it comes to juveniles. Right? So what is it, totality of circumstances? And then there were some specific parts we talked about juveniles in here. I'd actually be less concerned about the parts related to juveniles specifically, more just about the totality of circumstances. So make sure you focus in on that and really explain what that means. Don't give me like the 1,000-foot view that I tend to do. It's like, what it means is everything can be considered. That's basically what it is. It's everything from context to behaviors to everything. And you can put it in a way that anything that is completely legal can still add up to, hey, I've got probable cause. And so that's how that works. And then with that, we are out of time. We are done for today. We finished the review too. Look at us. We're cooking right along. We don't have a whole lot left. So we'll get this squared away. And then with that, I'll catch you all next time. Yay, I like that. You have a question or are you clapping your hands? I can't tell. If it's a question, go ahead and sound off. Or if you got, oh, there's a chat thing here. And so if you want, you can sign off in the chat, or if it's something you want to say, go ahead. Otherwise, I'll catch you guys next time. All right, you guys do the same. Have a good one. All righty. Bye.